Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Tim Beichel, we will be discussing trial technology and presenting information in a courtroom. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals and trial co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Welcome back to the show, Tim.
Thanks for having me.
I'm excited to be talking about this particular topic in light of our recent trial, in light of the role that you played a pivotal role as far as the trial technology is concerned.
Yeah, I appreciate that. And it was an enlightening experience, and I learned a lot through the trial.
Normally, I ask some information about people's background. In this case, I'm going to talk a little bit about my background. The way I got my trial experience was by learning trial technology, because hiring a trial technology firm to come in and support a case can be expensive. And if you're at a plaintiff's firm and you're looking to cut costs, an easy way to cut costs is to say, hey, instead of bringing along a trial technology company for X number of dollars per week, Miles knows the stuff. He's an attorney already. And then I would try and pivot my way into getting some witnesses and doing some other things. It meant that I was invited to trials more frequently and a lot of fun as far as that's concerned. Along with that, I got really granular on some of the information because I was paralyzed with fear at letting down the trial team in terms of something going wrong as the trial went forward. That's the backdrop, and I'll share with our listeners that I think it was our first day?
Yeah, it was a day of opening statements, I believe, actually.
Okay.
Yeah.
And we had a little bit of a hiccup when we plugged in and the dual monitor issue. And to back up a little bit, as we contemplate ways in which we're going to be presenting information, there are a variety of ways that one can present. And this is true whether one's doing it at an in-person mediation, at a mandatory settlement conference, at trial. You can choose to either use an old school platform like PowerPoint or Acrobat and just opening up things as PDFs, or you can use a more customized platform like, I believe OnCue is the one that we're using now.
Correct, OnCue.
A trial presentation software. Tell us a little bit about OnCue and how it differs from, say, a PowerPoint and its linear presentation style.
OnCue is a great tool, and essentially I view it as a database of pretty much all of your evidence or anything that you might potentially want to present to the jury at some point during the trial. Anything that you will want to display on that screen, you upload it to the software, and it is available in the software. And then the cool function is you have what they call the background functionality, and then you have the presentation software. And so this is the dual screen issue that we'll get to. But ideally, when you've set it up, the screen that is at counsel's table is the background screen, and that shows you what will eventually display to the jury once you click that present button. And then there's the presentation mode, which is the other screen, the screen in front of the jury, that will display to the jury what you've then decided to present. So it's a great tool because while, the attorney's up there maybe questioning a witness or doing the opening statement, you can be sitting in the background kind of going along with them, pulling up the evidence just in case they want to display it to the jury. And essentially, you don't even have to know where the attorney is going. As long as you have access to this database, you can have something up and displayed to the jury within seconds from pretty much any piece of evidence in the file.
Does it also allow for the presentation of video depositions?
Yes, and that was something we took huge advantage of throughout the trial.
And in the presentation of video depositions, this requires that when you get the video deposition from the court reporter's office or agency, that the video be what is known as synced with the transcript.
Right. Yeah, and when you get this synced file, an important thing to look out for is you actually are looking for two files. You're looking for the synced file, which is usually like an MDB file, and that has the actual synced transcript, but it does not have the video, which then you have to then go in and add the MP4 as well to the software after uploading the transcript file, which that was another issue we ran into. Was we were getting pretty close to having to display the video for this witness. And I realized, wait a minute, we have the transcript, but not the video file. And so there was a quick runaround to track down that video file from the deposition company.
One of the upsides about having a software program like OnCue, Trial Director was a previous one, Sanction was a previous one, TrialPad is a version, an app for the iPad. That's opposing counsel use TrialPad and use TrialPad very effectively.
Yes.
All of these are much more customized products, meaning they don't have the full testing and user interface and tech support that say a Microsoft product does. So while you can oftentimes call them and get some help, they're not that user-friendly. They have a lot of bumps. And if you're going to use them, it's not something that you decide, oh, you know what? We're starting trial tomorrow. I've heard that there's some trial presentation software. Maybe I want to use it. It's something that you put the time in well in advance to learn, vet the product. And then you also have to put a lot of time in to make sure that all the material you need for that backend database that you talked about are there. Is that fair?
Totally. And it's funny you say that because previously the firm used Trial Director. And when I was kind of appointed to this new trial tech spot, you had asked me to learn Trial Director. So I went and I spent a couple weeks trying to learn Trial Director in advance of a trial, probably the summer of 2022. I had learned it, fairly comfortable with it, and then we settled probably 6 weeks before trial. So I didn't really get that far into using the software. And then another trial came 6 months later, and we decided to use a different software because there was people in the local area who said, hey, we're very familiar with this, and we can give you tips and tricks. And this goes back to like what you said about Microsoft, where they might not have the big training manual that you need. So sometimes you got to find the people in the local area. So we switch over to OnCue because we have more resources to lean on to learn the software. Well, then I spent, again, a couple weeks learning OnCue. We get into the lead up of trial, but then we settled during jury selection. So we really didn't use the software then. Well, I thought to myself in the lead up to this trial, oh, well, I learned OnCue 4 months ago. I'm good. And then as we get to about a week before trial, and it's actually time to start testing this thing out and using it, I am like, wait a minute. I need to spend some serious time being 100% comfortable with this software. And it took me some time. I spent a lot of time that week further familiarizing myself, even though I'd done that just 4 months prior.
And there's a phrase, I don't know the origination of it, but the more you sweat in training, the less you bleed in combat. And I'd say that's true across the board as getting ready for trial, and doubly true on the trial tech side, because what you think is easy or, oh, all I need to do is drag and drop the exhibits in. When you start getting into it, you find, oh, yeah, I remember it being easy, but it's been some time since I've done it.
Yeah, mentioning the drag and drop of exhibits is funny because I was in front of my computer. We had just put together all of the exhibits, which in this particular trial, I believe was north of 800. And I thought to myself, well, I'll just take the 800 PDFs, drag and drop it in, and then the 800 exhibits will be there, all good. And I drag and drop it in, and it comes up with 800 error messages. And it's because the file names, the way this particular software works is it grabs the file name based off of the formatting of the file name. And the way we had done it was EX space, then number. Well, it took the ID as just EX for all 800 of them. So then my option was to go through all 800 and either do 001, 002, 003, which would have taken me, quite a while. Alternatively, this was kind of a cool little hack I learned, but there's a way you can go on through kind of the back door of the terminal and hack off the front EX of the 800 file name. So that's what I did. But it saved some time. But it's just one of those things that I thought this would be super easy. And then there was an extra 30 to 45 minutes involved with just uploading the exhibits. So it's never as easy as it might seem.
And this gets us into an interesting conversation because I have historically not used a trial tech. I have always done in-house trial support. And part of that is because I've always done it myself. And I'll tell you, this is the first time I handed it off to somebody else. And I don't do that lightly. It's a testament to the faith that I am willing to place in you as far as that work is concerned. But as people start evaluating, is it cost effective for me to do my own tech versus hiring on a consultant to come and provide all the support? there's a reason why consultants are so valuable, and it's because if you're doing it day in, day out, you know these issues, and an EX piece does not become an hour-long, oh my gosh, I named all of these wrong.
Exactly. Over time, I feel I will learn these tips and tricks, of course, and think this is what you had done over your 20 trials. You had learned them, and then you were very smooth and comfortable, and that's why it takes a leap of faith to hand it off to somebody new. But I appreciated you having done it, and now I'm trying to learn all of those tips and tricks so the next one's even smoother than this last one.
The other piece that I think is important to highlight is as robust as a program is with the exhibits, and I don't think we've talked about the cool aspects and why you want it done this way. And I described PowerPoint as being linear, and a trial presentation software program like OnCue as being, nonlinear.
I'd say organic or something like that, but yeah.
Meaning, as you described, when the attorney suddenly shifts or when a witness shifts and mentions something that you hadn't thought you needed in that presentation, you can just pull it up instantaneously.
Yes, and other examples are impeachment of witnesses. And let's say witness says something, and we did not get to personally use this very much in our trial because we did not have the video depositions of all of the parties or of all of the deponents. But what we could have done is witness testifies to something and they testified to something different in their deposition. If I have that page and line number, within 10 seconds, I can display the video of them saying that testimony to the jury, which is a very powerful tool and another reason to maybe record your depositions throughout the trial, throughout the life cycle of the case.
Yeah, definitely true. It is best practice to have them as video depositions precisely for that impeachment purpose. And that is where one of those programs excels, is being able to just drag and drop a section of the text from the deposition, right click, and immediately it starts to play. That's beautiful. The other piece in terms of the presentation, why use something that's complicated, is the call out function where you can pull up a whole document so that the jury can see that it is coming from a document and understand that they can have faith in the document, and then pull out a 2 or 3 sentence section so they can drill into a medical record or a policy or procedure that the defense violated, or in an economist's report where those numbers are always so small and there's so many of them and they're hard to see, but you want the jury to see them, you can pull it out that way.
Yeah, you can do the call out, blow it up, or you can also even highlight. There's a lot of options, draw, and there's a couple options. You can do it on your end and then display it to the jury, or you can choose to what they call it on-air publishing, which is the jury's seeing what you're doing as you're doing it. So it gives you multiple options as well.
Those are all the benefits to it. I will say I've done simpler cases and cases where there's been no video depositions that one has to work with, where I have just used, say, Acrobat and had all the exhibits there. And it's not as robust, meaning you have to know where you're going with a witness or expect where you're going with a witness. I find those are better when you've got, say, less than 100 exhibits and you can get them in your head pretty well in terms of what you're pulling up.
Right. When you're dealing with 800 plus exhibits, it's hard to, what's 566? That's a lot harder to keep track of. When you're dealing with smaller numbers, it might be easier to run that PDF system.
Yeah. The other piece, and we've gone kind of headfirst into the presentation software itself, I wanted to take a few steps back though, and those are some best practices in terms of making sure that the presentation doesn't fail. And with that, I want to take a step back in terms of going to the courtroom.
Yeah.
So, and this is where I feel it is so important to check the terrain where one is going to be, because even if you've been in that courthouse, even if you've been in that courtroom before, how well does internet work there? Usually poorly. How well do phones work inside if you're going to have to rely on a hotspot or something else? Also, usually given the construction of courthouse buildings, usually poorly. And I've had issues in some older courthouses where one plug works, one plug doesn't. And so it's going down there and talking with the clerk and figuring out what are the issues, or bailiff, what are the issues in this courtroom? Where is the screen usually put? Is this a courtroom of the future? Do they have all the projection systems already in place? And even if they do you really like where the screen is, or have they built out this whole wonderful courtroom and they have a built-in screen, but it's not where the jurors like to look in terms of turning their neck?
Right. It's funny because the first potential trial that we worked on, It was probably 2 to 3 months beforehand. And you kind of nudged me in a meeting and said, hey, Tim, yeah, maybe you should call the clerk and look at getting down to that courtroom and checking it out. And I was just like, wow, this trial is 3 months away. We don't know for sure we're even going to trial. Does it make sense for me to go down there now, take a look at the courtroom? And I'm thinking, this is before I'd personally worked on a trial, so I don't fully know what you're looking for. And in my mind, I'm like, it's a courtroom. They have trials. We know they have trials, so they've got to have power outlets. They've got to have a place to display, things to the jury. What could we be looking for? Now, after having gone through my first trial and going down to the courthouse and looking at everything, it totally makes sense. Because when we got there, they have one screen. It's a TV screen. It's probably 45 inches, and it is wedged in a corner where even if the jurors all try to turn their seats, they can't see the screen. And if we're displaying, well, in this case, we had witnesses appearing via Zoom. We displayed plenty of evidence via Zoom. If the jurors can't even turn and face the screen for the duration of a 3-week trial, it's not going to be very persuasive putting anything up on that screen. So immediately I realized we need a projector screen, but I then also realized the space here is really limited, and our projector, the throw on it is, 10, 15 feet, and I think this will cause an issue as well.
Throw, define.
Oh, sorry, throw. When you place a projector on a table and have it display on a screen, the throw distance is essentially how far away the projector needs to be from the screen to get that full size. So our old projector, oftentimes I would say it was probably 10 to 15 feet to get like a 100-inch display. We replaced it with a projector that probably 2 feet, and you get that 100-inch display, which means we can pretty much right at the foot of the screen, we can put the projector, which means, we don't have cords running throughout the whole courtroom. We don't have this huge mess.
It also means that the witness or the attorney isn't blinded by the projectors. They're walking up to show the witness something.
Exactly. And it means the jurors don't have to, crane their necks for 3 weeks, which I'm sure they appreciate it.
Would that be something that is known, if one is shopping for something like this, as a short throw lens?
Yes. Yeah. Short throw projector, short throw lens.
And while we're on the projector side, and I mentioned, I think earlier that, I get granular about this. And some of the granularity has come from learning.
Yep.
If you have a projector that has low lumens, meaning lumens is the amount of light that a projector puts out. If you go cheap on a projector and you get something that is less than 3,000 lumen, then you oftentimes have to dim the lights. When you dim the lights, the jurors go to sleep. So you want to make sure that if you're going to have that projector on frequently, that the lumens are in the 3,000, preferably 5,000 range.
Yeah, and I believe the projector we got has 4,000 lumens, and we had no issue with brightness or visibility, I don't think.
The cost on these units has gone down over time, and the lumens have gone up, and the decibels have also gone down. And that's the other thing that I've run into is oftentimes where you're putting the projector ends up being near the court reporter, and the court reporter controls the courtroom. We think the judge does. But at the end of the day, if the court reporter is unhappy and there is a loud fan, because the higher the lumens, the hotter it gets, the more it needs the below, and the below comes from the fan. So and these are things when you're buying a projector that you might not think about, but become very important. So where was the decibel rating on this? Where did that come in? It was less than 36.
I bet you I knew this at one point in time because I remember after I'd gone down into the courthouse, taking a look and seeing, well, one, we're going to need a projector and a projector screen so that the jurors are comfortable when they're looking at the screen. Two, we're going to need a short throw lens projector. So I came to you and I said, hey, Miles, would you mind if I take a look at a short throw lens projector? And you immediately said, yeah, these are the specs. And he said, we need at least 3,500 lumens. We need decibels here. And I took that list and ran with it. And we found a projector that worked great for us.
As soon as you're talking about video depositions or any sort of audio that's going to be played in the courtroom, a witness statement, you're going to be concerned about audio. And this also is a visit the courtroom. And here's why. Some of those federal courtrooms are enormous. And sometimes you end up in a situation where you need a couple of speakers to be able to cover everyone in the courtroom. The other is there are weird courtrooms throughout California. Marin is a particularly interesting one. Have you been in the Marin courthouse?
I've not been to Marin yet.
Are you aware that it is a Frank Lloyd Wright courthouse was the scene for the movie Gattaca and has been numerous other movies that want a futuristic setting.
Wow, that's news to me.
Yeah.
Excited to check it out.
It is an extraordinarily interesting courthouse. And when you go to the courtrooms themselves, when you stand in certain places, no one can hear you when you speak. When you stand in other places, everyone can hear you when you speak, even if you think you're only whispering to somebody else. Yeah. No, but certainly is something when you're trying to figure out, how am I going to project sound? From a sound perspective, did we use the speakers that were built into the projector, or did we use a studio monitor of some sort?
Right. We brought in a speaker that we plugged into the projector. And in my experience, sound on projectors is not all that great, especially when you need to cast it to a larger room. And so we brought a speaker, and this was a learning point for me. I went down prior to the start of the trial, a couple of days prior, to deliver much of the larger materials, the projector screen, the speakers, and also to get it set up. You'd asked me to get things set up, and in my mind, I needed to get everything down there, maybe plug some things in, just so we're ready to go. What did not cross my mind was, well, maybe I need to plug in the speaker, make sure it works. I just took for granted, hey, this speaker is going to work because it's a speaker. I know it works. It worked in the office. It'll work here. And I'll just plug it in when we're here in a couple of days. But then when we get down to it a couple of days later, when we're finally ready to display our first video with audio, and the jury's sitting right there and we're about to go, and I'm like, wait a minute, I haven't even plugged in the speaker yet. And I'm like, I hope this will work. And I ran over, plugged it in. Fortunately, plugged it in and it worked within 15 seconds. Volume sounded good. But if I had had a wrong cable or something else, that would have been a bad look and a teaching moment for me. And that was, I need to make sure my speakers are plugged in, ready to go before the first day of trial.
And this is a good practice pointer. And I learned a lot doing this over the many trials over the years as I built my skills. But one of them was, before you go to the courtroom, wiring up everything in the office to make sure that you have all of the equipment. And this is something that, because we have a lot of this trial presentation material, when someone's trying to try a lower cost case, can't afford a tech, don't have their own equipment, and because we're not in trial all the time, we get calls from people saying, hey, Miles, can I borrow your equipment? Which we're happy to do. But then the equipment comes back in varying states of completeness.
Yeah.
And so, one, doing the inventory, typically 90 days before trial, to make sure that all the cords that one needs are there in that regard. A common failing, if you're using dual monitors and everyone is using HDMI now, HDMI doesn't do well without what's known as a powered splitter. So if you're trying to have a screen and a projector that's different than the laptop, then that HDMI cable oftentimes needs a splitter, but if you don't have power to the splitter, then it doesn't split well.
Right.
And that's a device that I've had issues with it not coming back when I've lent it out. So this goes back to roughly 90 days beforehand, wiring everything up, testing everything, and making sure it all works. The other piece is, once you start getting those sync depots back, is making sure that the audio on the sync depots actually work, and doing it depot by depot to make sure that, in this case, we had defense counsel who had been taking depositions during the pandemic from home, and he had a really crappy microphone. And these are the various learnings of like, okay, well, if we'd known that before, we might have approached the audio differently. We fixed it in trial with the closed captioning.
Right.
And we fixed it. You fixed it in trial.
And initially, as you had said, we did not notice the audio issue. We just sit there in front of the jury. Hey guys, here's the video testimony of Dr. blah, blah, blah. And as soon as it starts going, the judge looks at us. He shoots the eyes at me.
He shoots the eyes at you because, for those of you who've watched Peanuts, it sounded like the way the adults sound on a Peanuts commercial.
And he goes, Mr. Michael, is there something wrong with your speaker? And I go, no, the speaker's working, Your Honor.
There's something wrong with defense counsel.
Well, honestly, the judge he let the jury go for the day, because at that point we had nothing to show, and you couldn't hear the
to
audio.
Be clear, it was 4:15, so it wasn't like a big loss.
Exactly. We were only going to show 10 minutes, put them to sleep before they have to head home. And but fortunately, then we got to put the closed captioning on. Super nice feature of this software was I had exported the video through the OnCue software to make the video that we would display to the jury. And as soon as I realized that we couldn't understand it, I could just go back in, click another button, and it re-exported it, but with captions. And it worked great. And that's how we ran with it the whole trial.
And I've made reference to what's known as a studio monitor. If you're building your own equipment package, we had years and years ago when I was doing this, we had somebody who was a musician, a bass player, in addition to being a paralegal. And he was the one who turned me on to studio monitors, which are a very compact, powerful, very high quality sound production. And the reason for this is deposition sound quality is usually not great to begin with, and even worse when you have issues like Zoom or not a great microphone or what have you. And the crispness of a studio monitor and the ability to really crank up a studio monitor, it can fill a space like a courtroom in a very powerful way.
Yeah, the speaker worked great for us, and it was definitely a necessity.
The other piece, when I talk about sweating in training versus bleeding in combat, I had my own panic moment in a courtroom when we went to play a video depo and there was no sound. And the previous depo had played just fine on the same system with the same speaker and everything else. And I had the good fortune of having that same paralegal who was the musician. He happened to be in the gallery that day. He was watching a little bit of it. And as I'm fiddling with this, he comes up, and apparently on occasion, a video depo operator will record something in mono instead of stereo. And because it was recorded in mono, and because we had two outlets for the speaker, only one was plugged in, he said, switch them. So I switched. It was the right and the left. So it didn't matter which one it was. I just switched the cable that was plugged into the speaker from the one that wasn't plugged into the one that was plugged in. Problem solved. These are little learnings that I've actually had that happen about 4 times now in trial where it has been recorded the wrong way. And just that switch takes you from no sound to having sound. Those are the little pieces where a trial tech firm or a little bit of experience of it not going the right way will teach you how to have things work out.
In that situation, I would be sitting there for forever trying to figure out what the issue was. So yeah, those little learnings, they really help.
And the prickly feeling of sweat that just roars up your back when something is not going right in court. The amazing thing that comes with that is you will never forget that lesson.
It's hard to articulate how much I can relate to what you just said. Before you go to trial, there's all this conversation around it. It's this buzzword, if you will, trial, all that comes with it. And you kind of just speculate, what's it going to be like? And then you get into it, and you're right. The thing that I will always remember is those few moments where I was like, oh, wait, I'm starting to get a little nervous here. And vast majority of the time, we were able to control for it. Everything turned out all right. And it was because of preparation and training, but still doesn't feel good to get nervous. And I feel like as I spend more time mastering the trial tech and how to handle the tech and handle myself in the courtroom, I will feel more comfortable in that situation.
And this is a good segue into backup plans, because no matter how much one controls for unexpected outcomes, one almost always, as I tell these stories, I make it sound like, oh gosh, I've done everything and I've had everything fail. Now everything as we go forward is perfect.
Yeah.
Which is not the case. As we go forward, mistakes continue to happen. Mistakes happen because that's the live nature. It's the difference between seeing a movie and seeing the theater. You know, a trial is live. So on the backup plans, one of the things that we asked you to bring down was butcher block paper. And why did we ask for that?
Well, the butcher block paper was to display something to the jury. This is actually a very powerful tool that you like to use, which is write up information that is important for them to remember and then just keep going back to it over the course of the 2 to 3 week trial. It's something that kind of sits with us in this courtroom together and something to refer back to. And you kind of put your big points up there and they remember them.
This is something that as a young lawyer thinking I am part of the technical age, and I thought that, wow, we can present everything. And it's some of the older lawyers that I worked with that reminded me how important it was to have something, one, a piece of evidence that's physically created while in front of the jury. That has validity. They saw that butcher block get built with a witness. The other piece is that you might have 800 exhibits. They're not all going to be on the screen at the same time. The moment you move on to something else, it's gone. So whether you use foam or, a blow up, large pictures, or whether you use butcher block, or whether you use other tools, those are pieces that are in front of the jury all the time. And they also become what I was referencing earlier, which is the backup plan. Because things break, the projector bulb blows up, and suddenly you're without a projector. Well, your choice is, do I bring 2 projectors to every trial? Probably not. Maybe you do for opening or closing, if you're really, really worried about not being able to do it without the presentation. But every lawyer I know with opening or something along those lines also has a backup plan for opening. So what happens if I can't show the things I wanted to show? Do I have blow-ups? Do I have 12 copies of my presentation? Say, gosh, I didn't expect this to happen, but fortunately, I happen to have 12 color copies of this. Judge, do you mind if I publish this so that people can follow along? So I know that Andrea, our co-counsel, had a backup plan in place for her opening, just in case.
Wow. Yeah. See, that was not something I was aware of, but you always got to have that plan B. And there were other situations that I was realizing that I was kind of preparing a plan B. It was just for my own comfort. There was the first day I plugged in an HDMI cord and it worked, and it worked just fine. But then it was actually the next morning I was in the shower, and what sunk into my head was there was one time I was using my computer and the HDMI cord gave out, and I don't want that to happen down there. So I drove over to the office, grabbed another HDMI cord, and just kept it in the car. So that way, if the HDMI cord ever gave out, we would have one on campus with us ready to go. I did not want to ever be in the position where we don't have something and it's because, we were not prepared or we did not think about it. So
this particular judge was pretty kind. He let us try our case. If we had an issue like where we had to end at 4:15 one day instead of 4:30, he was not upset. I think part of that was because we were so far ahead of schedule and we worked well with opposing counsel.
Right.
There are judges who will not allow that, where if wait a minute, that doesn't work at 4:15, you better have a live witness, or you better have something because we are not wasting a second of these jurors' times. The moment you stop having something in my courtroom, your case rests. It's now the defense case. So that's where, the concern about making sure everything is pulled together comes from.
Yeah, that would not be a position I'd want to be in.
Final thought on backup plans. They're less popular now than they used to be, with some lawyers who are not as good at thinking ahead of what they need. One of the great tools can be an Elmo. Document camera Elmo is a brand name. And for those who watched the OJ trial, one of the tools that they used a lot in that case was what's known as a document camera, which allowed whatever you put under it, whether it's a piece of paper or a piece of evidence like a gun or a glove or what have you, you could drill down onto it. And with some lawyers, they use that, they forgot that they wanted to have this particular piece of paper as an exhibit, and then they can put it on the document camera and have it marked. And it's easy way for people who are less planners.
Good tip.
Yep. Are there other things on the technology front that you think would be useful from your recent experience? Do you think for those who are going to be going into court or doing a presentation where it's a do or die situation that you would want them to know?
What was most important to me was the idea that I really cannot display something to these jurors that I'm not supposed to display. And that's kind of a weight that I really carried with me throughout the course of the trial. And I know, mistakes happen, and I'm sure it happens all the time. Somebody accidentally displays something very briefly to a jury, and probably not anything that comes of it. But I did not want to be the guy to display something that, we really should not display to this jury. And because of that, I would, for example, if you had a witness exam, you would often, prepare an outline and maybe have some of the exhibits that you plan to display. And we, over the course of the trial, had developed a system that once you had finished your outline, you'd get it to me, you would list all the exhibits you might use. And then I would take those, 10 exhibits and isolate them in what they call a workbook on OnCue. And then when it came to that witness's exam, I would start with just that workbook. So that way I was only able to select from those 10 exhibits without having to click back out and go back to the initial 800. It allows you not to really fat finger, an exhibit you don't really want. So these were just the things that I learned a lot of ways to kind of ease my concerns along the way, which I think is super important, because otherwise I could have been a nervous wreck at times during that trial if I really wanted to be. But I took the time to prepare, learn the software, and really make sure that I felt comfortable and confident enough to use it and use it on the spot. And that helped me sleep at night. And I think it helped the rest of us feel more comfortable. So I think the big takeaway is preparation. And it's partially ironic saying that now because this was my first trial. And I don't think you can be fully prepared before your first trial because you don't know what to expect. But the next one, I will be even more prepared. And I look forward to it.
It's that level of knowledge that I think we've talked about on the show sometimes, from unconscious incompetence to conscious incompetence to conscious competence to unconscious competence. Those levels of knowledge.
Yes. Yep.
You raise a very good point, though, and I'm glad that you brought that up. The idea of having a good witness outline and, in essence, providing stage directions to the person who's giving your trial support so that they know, I do want this exhibit displayed when I get to this point. I'm going to reference it, but I don't want this exhibit displayed. And knowing what's been admitted and is allowed to be displayed versus not admitted, and not making that the trial tech's job, but the attorney's job.
That's why earlier I had referenced when the attorney goes off script, on cue is great because, I could pull up another exhibit. But ideally, we've worked out kind of where things will go, and I can be even more prepared than just 800 exhibits in front of me, find the correct one. You can become more prepared than that, but the nice thing being you always have that option in case you go a direction you don't expect to go. You're ready. Trial software, it's a great tool. Highly recommend it.
Wonderful. Well, as always, Tim, thank you for being on the show.
It was a pleasure.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on how you successfully approach trial technology. Like what you heard? Share us with a colleague and leave us a 5-star review on Apple Podcasts. To all of you doing justice out there, happy hunting.